we've been told, because of what we're reading in the media, is that the representative or representatives from the Attorney General's office plan to take approximately a week to present the evidence in the Jayland Walker case. What would that evidence look like? Well, it's going to be testimonial. Witnesses will testify. Various forms of electronic evidence, such as video, body-worn camera images, pictures, and even audio. It could be forensic evidence, and even forensic experts may testify as well. That's just an example of what it could all be. The understanding is that the Attorney General's office will present all 8 officers involved in the Jayland Walker case to the grand jury. Now, the defendants in any criminal case have an opportunity to testify. Certainly. That includes at a trial jury, or that includes at a grand jury. But a very important distinction between grand juries and trial juries are if a defendant wishes to testify before a grand jury, they do it without their attorney. As I mentioned earlier, a defense attorney does not have a place in front of the grand jury, and therefore, if a defendant wishes to testify on his or her own behalf in front of a grand jury, they would do so without the presence of a defense attorney. The grand jury is a little bit different from a trial jury in that it's a little bit more personable. At trial juries, jurors are generally not allowed to ask a lot of questions, and if they do, it's very structured. It goes through the judge. It's very structured on how that question gets to the witness. That's not the case with grand juries. Grand jurors can ask all the witnesses questions and often do so. As I mentioned earlier, though the grand jury proceedings are confidential, they are recorded. They are recorded. All of the evidence given to the grand jurors, whether it's testimony or reports or video, it is recorded. Their deliberations are not. And in the grand jury process, the judge provides them the basic law. And I mean the basic law on how they are to operate, how are they to conduct themselves as grand jurors, how are they supposed to conduct their deliberations. The prosecutor provides them the law of the types of offenses that may apply to a particular incident. And then if the grand jurors have questions, they can, at times, seek instruction from the judge into specifics of the law. Ultimately, once the judge instructs them and the prosecutor provides them the various laws that are applicable, the jurors begin to deliberate. And probably the most important distinction between a trial jury and a grand jury is a trial jury requires a unanimous verdict. That means all of the jurors must vote that somebody is guilty or not guilty. That is not the case for a grand jury. In a grand jury, as I mentioned earlier, 9 people will hear the matter, and it requires 7 of 9 people to agree that there's probable cause to charge somebody. Again, 7 of 9 people have to agree that there's probable cause to charge somebody. It does not require a unanimous vote. Now let's talk about what that ultimate result is. There's a few terms that you'll hear frequently, and I'm going to explain those a little bit when we talk about what it looks like when a grand jury decides to make its decision and report out. I will say these things happen very fast, so though we have some timeline from news sources from the Attorney General on how long it will take to present the matter, we have no idea on how long it will take grand jurors to deliberate on the matter. All we can ask is that they take everything into consideration, put their full time, energy, and focus, and come up with the most full, thorough, and just result possible. So what you may hear when a grand jury makes a decision is you may hear one of 2 words. You may hear the phrase true bill, or you may hear the phrase no bill. A true bill means that a person has been indicted and that there's now formal felony charges pending against a person or persons. And what would happen next is the traditional criminal justice process. That person would then be arraigned before a judge. There would be various pre-trial conferences where the prosecutor and a defense attorney determine what's going to happen in the case. Is the individual going to resolve the matter and plead guilty? Is the individual going to want their trial? And then ultimately there might be a trial. The other phrase that you might hear is no bill. No bill means that the grand jurors did not find sufficient probable cause to charge a person or persons with a particular offense. It represents a closure of the criminal matter against that individual. There's certainly other things that may happen, but that person isn't going to be subject to any further criminal culpability. So again, true bill or indictment means that an individual has been charged, and it will now begin the traditional criminal justice process against that individual. And no bill means that the person is not charged, that the grand jurors did not find sufficient probable cause, and they are discharged from any further criminal culpability. Since there's a group of individuals, 8 officers involved in this particular incident, it's important to note that this is not an all or nothing decision. In other words, yes, all 8 officers could be indicted and charged with some offense or offenses. Vice versa, all 8 officers could be no billed and all discharged from any further criminal culpability. But there could also be a combination of those two. Hypothetically, 5 officers could be indicted or true billed and charged, and 3 officers could be no billed and they're discharged from any further criminal case. So we don't know. There's a lot of variables that we're all walking into, but it's important to note that it's not all or nothing.